What's up, college football addicts? Big day yesterday. We talked about it with you, but we're going to continue to talk about why the ACC may have just accidentally shot themselves right in the foot. Now, the sports media world is going crazy with the recent news about Clemson joining FSU to fight against the ACC. But a lot of people missed something deep within Clemson's filing that more people should be paying very, very close attention to. Clemson's attorneys made an absolutely epic logical argument against the ACC. They used the ACC's own legal argument completely against themselves. We're going to get right to it, but before we start, do me a favor and hit that subscribe button. We have been all over the conference realignment stuff, and we have more news dropping very soon on North Carolina and other teams that you are not going to want to miss. So hit that button and let's get after it. Now, per Clemson's recent filing, they said, further demonstrating the absurdity of the ACC's misinterpretation of the ESPN agreements and the grant of right agreements, the ACC Constitution allows for members to be expelled by a 3/4 vote, excluding the vote of the school being expelled. So the ACC Constitution, certain section, under the ACC's interpretation of the grant of rights agreement, would have the power to expel a member without that member's vote while still owning the rights to that former member's future games for the next 12 years. That's an illogical outcome that is not supported by the grant of rights agreement, plain language. So I know that was written by attorneys, but I'll break it down for you further. The ACC is literally arguing that it can expel a member. It can kick a member out with 3/4 of a vote, while also making the argument that it would continue to control that member's media rights for the next 12 years. That's right. You guys heard me right. I'll say it again. The ACC could kick Florida State, Clemson, Miami, whoever out and still retain their rights for the next 12 years based on their logical arguments. Illogical arguments, if you want to put it that way. You cannot make this up. Now, I know some of you pro-ACCers down there are going to be in the comments telling us how the ACC didn't say this. Yes, they did. They absolutely did. They said it. They may have said it in two different locations at different times, but when you chain together their own logic together, it is irrefutable. This has always been their stance, and I want to give full credit to the Clemson lawyers for connecting these dots so people can see how evil and asinine this conference is. I think the ACC truly knew that this is possible. I think they always have known this and had it in their back pocket. I think they've always known, hey, at the very least, we will have this trump card over anybody who crosses us. Now, what I want to tell you is that if the ACC executed that, if the ACC, let's say, kicked Clemson out or kicked Florida State out and then tried to retain their rights, I think at that point, Clemson or Florida State or whoever it was would sue the ACC, much like they're doing now, but they'd sue for their rights back. They'd say, hey, you kicked us out of the club. You can't retain our membership fees, our dues for the next 12 years. And I think Florida State or Clemson would end up winning. I don't doubt that at all. But I think the ACC has always known this and has always had this in their back pocket so that they could use it as a threat, so they could use it later against teams that cross them. We already know about the nepotism, the conspiracies that Florida State has floated about the Swaffords and Raycom and this, that, and the other. You don't think this conference that is a nonprofit, that is all about themselves, all about taking care of those Tobacco Road teams, which I know they're going to be in the comments. I'm prepared for it. Bring it on. You don't think this conference would do that? You don't think the ACC has that within them? Clemson continued by saying, similarly, under the ACC's reading of the grant of rights agreements, Clemson could withdraw from the conference, pay an exorbitant withdrawal penalty to the conference, and join another conference, but the ACC would still own the media rights to broadcast Clemson's home games through 2036. This nonsensical reading of the grant of rights agreement is wrong, and it's inconsistent with the plain language of the agreement. Now, again, Clemson attorneys, you hit the nail on the head here. Nonsensical is the perfect word. I'm not a lawyer, but this type of legal contortions in a contract is pure nonsense. And we've talked about this. We told you there was a reason that Clemson was being intentional about filing. There's a reason they didn't do it in December. They wanted to see what the ACC was going to argue against Florida State so that they could have an even, I don't want to say better, but an even more precise lawsuit. Florida State and Clemson just need to go 1 for 2 here. They don't necessarily both need to win. If one wins, the jail is sprung free and they're both out, and other teams probably as well. I've heard from several practicing attorneys who would agree that the ACC is in real trouble here. In my recent conversations with attorneys, both on and off air, several things have been outlined as problems for the ACC. Things like the fiduciary duties that they're not living up to. Things like the liquidated damages. What are those things? Well, fiduciary duties basically comes down to the fact that Clemson and Florida State are saying, hey, we signed this agreement with you. You said you were going to have our financial best interest in mind, and you haven't done that. You haven't even been close to doing that. What are the liquidated damages? Talking about how the media rights estimated at $500 million, Florida State having to pay that is essentially a penalty. And that is something that both Florida State and the Clemson Tigers are both arguing against. And they're very strong points for these universities. Attorneys are spot on with them. And the ACC is in a lot of trouble. But the biggest problem that the ACC has right now is that they're arguing one thing in Tallahassee and another thing up there in North Carolina. And it will happen with Clemson too. They will be arguing one thing in South Carolina, and then they will be arguing another thing in North Carolina. They're arguing against themselves because they're trying to get things dismissed in one state or continued on in another state, and their arguments are not congruent at all. They are off base. Now, fortunately for them, one court case does not determine what will happen in another one. And so you can have differing arguments. Clemson, though, is pointing that out. In their lawsuit against the ACC, they're saying they're not consistent here. They are completely wrong. What do you guys think about the most recent ACC gaffe? Let's talk about it down in the comments. And we had a lot of success recently doing a mailbag episode with you guys. And if you guys take the time to come up with good comments, questions, share your own personal thoughts, call me out on something that I'm wrong on. I'm good with that. We may do another mailbag episode here in the very near future. In fact, I think the last mailbag episode we did, I'll have to go back and watch, I think it had 2 things where people disagreed with me, and we gave answers to that. You may have liked them, you may not have liked them, but I'm all for the conversation. You ACC, pro ACC folks, I know you're going to be down in the comments. I know that Jim Phillips' burner is in here, and you basketball only folks are going to be down there commenting. I'm here for it. Let's talk down there. Listen, this is the most fascinating story in all of college football and really will be for the next couple of years. Make sure that you're subscribed to College Football Addiction so you don't miss any of it. And I appreciate you guys, as always, for tuning in here to College Football Addiction.